Good evening, everybody. I hope you are all doing well. It is uh, October 8th, 2025, Wednesday. I was not here last week, but I hope everybody had a good first week of October, and we're looking forward to a little bit of cooler weather. Already seeing uh, the nightfall coming a little quicker, and the cooler weather hopefully be here soon. So again, I hope everybody's doing well. Just want to make a comment because I have gotten a couple of questions about some of the news stories you may be seeing about Social Security changing the rules to eliminate age as a factor in making disability determinations. And right now, this is all, speculation as to what might happen. Nothing has been put forward as legislation. There have been no formal proposals by Social Security. Um, again, some of the folks that are commenting are saying that, they want to get rid of the grid rules or get rid of the grid rules at 50 and 55 and only have them applied at age 60, and that, age would not necessarily be a factor. Again, we'll see what happens. That very well could happen. I think we're a long way from there. And again, I suspect that there's some argument that this might be something that Congress would have to do. It's a pretty substantial change. Certainly, if you do communicate with your elected representatives, let them know that age should certainly be a factor in a disability determination. The whole premise of the grid rules, I've got a website called gridrules.net if you want to look at it, is that when people are older, over 50 and especially over 55 and over 60, that the odds of getting a job when you have a significant medical problem are greatly reduced. I mean, imagine somebody who's got, a couple of herniated discs, has surgery, 2 surgeries, 3 surgeries, and is taking, pain medication, even tramadol, or maybe something stronger, oxycodone. A person like that, let's say they could get a job doing physical work, whether it's in a warehouse or construction. But the reality is, who's going to hire a 57-year-old with a bad back? And I think that that's the premise of the grid rules. It was really designed to help people who are in the construction business, be found disabled, even if they have some capacity. And that's what the grid rules say, is basically, even if you have some capacity for work, whether it's sit down work or light work, you can still be found disabled, because as a practical matter, Social Security realizes that jobs don't really exist for people, again, over 55, let's say, with significant medical issues. The grid rules can be applied mechanically. And look, I will tell you, there have been times I've seen where, the grid rule gets a case approved and the judge doesn't really go beyond the grid rule. And, is it possible this person could do some sort of work? Possibly. Again, the problem is when you're over 55, you're going to have more health problems. And a lot of folks, there's a term out there called worn out worker. And if you've been doing physical labor for 30 or 40 years, you may be okay today, but the reality is you're probably going to be much more susceptible to, medical issues going down the, line. So my guess would be that if they got rid of the grid rules or they changed the rules, many judges would still recognize, and again, there's a lot of leeway that judges have, many judges would still recognize that people over 50, especially over 55, maybe 50 to 55 is not as much, but people over 55 are going to have a really hard time adjusting to a new type of work. So it wouldn't surprise me if judges on their own, even if the grid rules don't exist, made decisions that recognize the reality that people over 55 certainly have a much more difficult time sustaining work. So even if the rules change, I suspect many judges will continue to give that concept and that reality some weight when they make their decisions. But we'll certainly see. We'll see if there's any formal changes. Again, if you do communicate with your representatives, elected to federal, not state, but federal, U.S. Senator, U.S. representatives, let them know that, changing the grid rules is really unfair. It's going to put a lot of people behind the 8 ball. And again, no matter what side of the political spectrum you find yourself on, I hope we all can agree that people that no longer have the capacity to work because of a legitimate, significant medical problem, that there should be a safety net. We shouldn't have people starving in this country. And, people, it's interesting because sometimes I'll be talking to people and I'll tell them what I do. And, some people, the first thing out of their mouth is, well, there's all kind of fraud in Social Security. It's just a knee jerk. They don't know any better. That's just what they hear. And my response is, for every, case of questionable approval, there are probably 50 or 60 people that should be approved that are not. Social Security makes it really, really hard to win. And there are far more people who are denied, they shouldn't be denied, than the other way around. So the system, if anything, is really, really difficult to navigate. As you know, if you've gone through it, it takes a long time, 18, 24, 30 months at times. The standards can be really unforgiving. The judges can be arbitrary, Social Security can be arbitrary, and waiting for 2 years, for a decision about about your disability is really, really difficult. So anyway, I just think that we're a long way from that. We'll kind of keep an eye on it, but that's just my thought about that, because I do get questions about that. But right now, there's nothing in the pipeline. We shall see if it happens by the end of the year. I think right now they're trying to get the government working again, which is the second thing. Let me talk about very briefly. Generally speaking, the Social Security disability is not affected by the shutdown. There's very little that are considered non-essential in the Social Security disability world. So we've not seen much of anything. There have been some reports that certain state agencies that are funded by the government, that there may be some slowdown there. Again, nothing is going to, if anything, it's going to keep things, in these sort of long delays. But I don't really see anything at this point that has made things a lot worse, at least at the disability adjudication level. So, okay, let's kind of jump into some of the questions. Joe, who's a longtime viewer, and Joe and I correspond periodically by email, and he's asking about the Division of Quality Services for an ALJ misconduct complaint. I don't know much about that, Joe, quite honestly. I've never filed a misconduct complaint. I know people sometimes do, and obviously that's a pretty significant charge to say that a judge, acted to the level of impropriety that would be judicial misconduct. I suspect that they do investigate them. The OIG's office or Division of Quality Services do investigate those. I suspect that it's probably going to be an uphill battle. But, again, let us know how that turns out. Joe's also filed an appeal on a case. Obviously went to a hearing, and he got a letter that the appeals council's got jurisdiction, and you could be waiting 4, 5, 6 months or longer before you get a decision on that. That's just the way that is. Okay, so we just talked about that, Joe, about the online article. I think you may have sent that to me even. I know a couple of people have sent me articles. And you do make a good point about this, that if you are thinking about applying, I'd go ahead and do it, because many times when they make substantive changes to the decision making, there's a cutoff date. So people who have an active claim before the cutoff date, they get adjudicated under the old rules, i.e., the grid rules would apply. If you wait and the cutoff date is, let's just pick a date, October 1, 2025, they may not tell you the cutoff date until after it's already passed. So in other words, they don't necessarily want a bunch of people filing. So you have to, let's say that the new law goes into effect, we may not know the cutoff date right away. So I think given that disability is a long process anyway, no reason not to apply as long as you're not working. But if you're thinking this may be a route to go, and you're concerned that they're going to change the rules, I would tell you, go ahead and get that application in process. I think that that's going to give you a much better chance of being adjudicated under the current rules. And again, we don't know what the new rules, if any, are going to be, but I don't know that you want to be dealing. I think it's fair to say that any new rules are not going to be claimant friendly. So if you're thinking about it, Joe's very correct. Go ahead and do get an application going, assuming you're not working. And I get this question sometimes. People will say, "Well, should I quit my job and apply for disability?" My general answer is no. I think that if you're able to work, you should work. The whole idea of disability is, it takes a long time. There's no guarantees, and you're much better off with, earnings that you're gonna get. You will feel better about yourself. You'll feel more useful. Generally speaking, there's very rare situation I would tell somebody to stop working to apply for disability. Maybe if their earnings are just barely over SGA. Again, SGA is $1,620 gross per month. Let's say somebody's earning $1,700, and they think that they're going to have to even cut back from that. At that point, you might say, you know what, let's get it below the 1620 so I can go ahead and apply, because again, the trend is not in your favor. But generally, otherwise, I would tell you not to stop working. Now, if we do get the sense that the changes in the rules that are going to be really detrimental to claimants, if that starts to get some legs, then I would tell people, be aware of that, and you may have to make some difficult decisions about whether you want to continue working or pursue disability. But generally speaking, I would say continue to work as long as you can possibly work. All right, SA says that his or her, I'm not sure if he or she, psychiatrist recommends ECT, electroshock treatment for major depressive disorder 3 times a week. Can't drive, 10% chance of long-term memory loss or short-term memory loss. I'm not taking chances. Do I have to go to the ECD provider consultation? No. Social Security has a ruling, which is kind of like precedent in the Social Security world, that says that if a doctor suggests a procedure that is dangerous, whether it's medications or surgery or ECT, electroconvulsive treatment, and you're concerned about the side effects, memory loss, permanent damage, paralysis if it's back surgery, you're not obligated to do it. They can't hold it against you for not undergoing something like this, which is really, really serious. Now, again, whether you and your doctor have to make a decision whether it makes the most sense. If you're struggling with treatment-resistant depression, you may decide that this is something to consider, this or ketamine or some of the more sort of second-level treatments. But no, you don't have to do it. And, I would certainly hesitate to take a treatment that gives, has the possibility of, wiping my memory out or changing my personality or causing long-term brain damage. Certainly do your homework on it, but no, you don't have to do that. Okay. Kevin Johnson says, I have an ALJ hearing with Charles Howard after your birthday. What's his approval rate? Well, let's see if we can tell you that. Let's see, you said it was Judge Charles Howard. So let's take a look at Judge Charles Howard. And again, I don't know what it's going to be. Let's see what it says. Charles Howard. Let's take a look. In Tennessee. All right, according to, there's several websites I go to, he has got a approval rate of about over 60%, which is quite high. So I would think it's fair to say you drew a pretty good judge, a really good judge. So I think that you're going to get a fair hearing with Judge Howard. I don't know him personally, but that's a pretty good approval rate. So 66%, 59% fully favorable, like 7% partially favorable. That's pretty good. And, I would say that when you have judges that are in the 60s, they go into the hearing looking for a reason to approve you, as opposed to a judge in the 30% who's looking for a reason not to approve you. So I think that that's pretty good. So Kevin, I think you drew a good judge, and I hope it goes well for you. Okay. Spine surgery journey says my workers' comp review doctor denied my third back surgery. With my surgeon's notes reflect I need it for my SSDI approval. You're in recon right now. Now, the question I guess I would ask would be, why did the workers' comp doctor deny or not recommend the third surgery? Was it because of financial considerations, like what the insurance company is concerned about? Are they concerned that the surgery, the chances of success are quite low? Many times I see situations where somebody's had 2, maybe 3 surgeries, and then the doctors they go to are saying, you've had 2 or 3 surgeries, you've not gotten better. you may be one of those individuals that forms scar tissue very readily, or the odds of success in a third surgery are just not really great. So you may be kind of headed towards um, long-term pain management or pain mitigation in some way. So I think that probably helps your case. If you've had surgery, you're no longer a surgical candidate, basically that means that the fix, as it were, is not available. There's no surgical fix for what you can do. And so you're as good as you're going to get. Now, if you're getting workers' comp, realize that workers' comp offsets disability most of the time. When that means that as long as you're getting your TTD benefits from workers' comp, those months when you look back and go back for past due benefits, you will not get past due benefits for months where you got TTD, if TTD is the weekly wage benefit from comp that exceeds your Social Security. So, sometimes I get calls from people and they want me to take their case, and they're in the middle of a comp case and they're getting benefits. And I say, I'd love to help you. The problem is there won't be any past due benefits. There's nothing for me to get paid with. I get paid a percentage of past due benefits. If you're getting comp, can't really help you there. And so I usually will say, once you settle, we can look at it. Now, again, you can go ahead and do it and get approved. And then once the comp case settles, and you want to make sure you have language in there called Hartman language that basically says that your lump sum represents payments over your comp lump sum represents future payments over the expected lifespan. But for Social Security, you can get it. You won't see any money or any past due benefits until your comp case is over. And there may be reasons to do that because you maybe have a date last insured problem. The other thing you want to be careful about, and again, I don't want to go into exhaustive detail about this here, but this is a question to ask is, as you know, with SSDI, you become eligible for Medicare 24 months after your first payment. Many comp settlements will basically say that you need to do what is called a Medicare set aside, because Medicare does not want to pick up the cost of work-related injuries. So if there's Social Security involved, there may need to be a Medicare set aside where a chunk of your settlement needs to go into an account that is designated for medical care. And Medicare set asides, also sometimes the language will say that you agree that you have not or will not file for Social Security for, let's say 3 years. And that's because, again, Medicare don't want to get stuck paying for work-related injuries. So it gets complicated. Comp and Social Security don't play well together. At one point, there were different rules in different states. Most states offset Social Security with comp. Other states, comp, was offset by Social Security. I think it's now all where Social Security is offset by comp. But these get really complicated, very granular. And so if you have an attorney for your comp case, you might want to talk to him or her about that. If you have an attorney for your Social Security case, and again, the attorney needs to be aware there's comp involved, you need to talk to that attorney about that as well, and just get these things coordinated, because it can be very complicated. David Bessiere, good evening. Thank you, David. I appreciate that. Actually, I got to get some more videos out. We've got a bunch of them that I've written up, kind of the what I want to talk about. I just need to get down here and do the recordings and get them edited. But we'll get it done. Not anything else. Just I get busy. Had a busy few months trying cases, which is good. But I got to get on the video as well. So we'll hopefully do that. I got, of course, a bunch of these live streams. I can take parts of them and make videos out of that. It's just function of time. That's it. Killer of Demons says hello, Killer. All right, Sarah D. I'm waiting for my hearing at the end of the month, October 29th, and pending knee surgery, ligament repair, cutting and shifting a part of my tibia with hardware and screws. A few days after your hearing, will the judge consider my hearing? Would a functional capacity prior to the surgery help your case? I think so. I mean, I think that realize that you alleged an onset date that was, I'm assuming, a year and a half, 2 years ago. And what a judge could do would be to say, well, clearly you need this very invasive and difficult and multi-part surgery now. That certainly suggests that you have a significant problem and have had one for a period of time up until this point, and therefore you should be deemed disabled. What the judge might do is put this on a 12-month or a 24-month review to see how the surgery that you're having at the end of the month is doing, and whether that solved the problem. But yeah, I mean, if you think about it, when you go to a hearing, if you go to a hearing on, I think you said the 29th of October, that's going to be looking backwards at onset date through the date of the hearing. And if in fact, and hopefully the case will be that you have a very successful outcome to your surgery, that doesn't make you less disabled before the surgery. So, obviously getting a functional capacity form discussing your functional status, as of your onset date through the date of, the current time. And certainly really the more important thing is to go back into the onset date. That would be very helpful. Functional capacity forms, and you've heard me talk about them. Some people call them RFC forms. That's really not an accurate representation. I'm just going to move this. It doesn't chopped out here. RFC stands for residual functional capacity. That is a legal determination, not a medical one. It's a legal determination that you have the following residual leftover capacity after factor in capacity for work. Let me put it that way, after you factor in your medical issues. So a residual functional capacity might be a person who's limited to light work with the following additional limitations: no climbing. And light work, by the way, before I get into that, light work is defined as standing and walking 6 out of 8 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion. And that's a fairly common, starting point for an RFC. So that's where you're at light work. But a judge or Social Security administrator, adjudicator rather, might add to that, this person limited to light work, but in addition to that, cannot climb ladders, ropes, and scaffolds, cannot work around unprotected heights or around dangerous machinery, needs to avoid extremes of temperature, meaning anything over 80 degrees, anything under 40 degrees, needs to avoid respiratory irritants like dust, fumes, and gases. Let's just stop there. Well, right there, there's a percentage of light jobs that exist that would be eliminated by those added limitations. Again, jobs that require climbing ladders or scaffolds, they may be light jobs that require that, but those would be out of the picture. So that is considered, that what I just gave you is a residual functional capacity. And at a hearing, what the judge poses to the vocational witness are questions that are, in essence, residual functional capacity assessments. And what judges may start out with is a very mild, somewhat non-restrictive RFC. And then as the questions go on, we keep adding to that. So let's say, in addition to that, what I just gave you, now let's say this person, because of attention and concentration issues, would be limited to 1 or 2 step simple repetitive tasks. Well, now that eliminates a whole nother category of jobs, jobs that require more focus and concentration. But there still might be jobs available that are 1 or 2 step level simple tasks. Then we might say that a person needs to be able to have a sit-stand option where they can do the job sitting or standing. Eliminates a few more jobs. Then we get to the ones that eliminate a lot of jobs. The person would be off task, and off task would be not focused on the job at hand for 15% of the day. Or some vocational witnesses say 10% of the day, which is, I never understood that, why you have that variation, but be that as it may. So if you're off task 15% of the day, that means that probably an hour a day, approximately, you're not going to be focused on your job. Well, most employers and vocational witnesses will tell you that really no employer is going to let you be off task for 15% of the workday. Or if the judge says this individual is likely to miss, 2 days a month because of symptoms, that's another example of a problem with work reliability that would not be tolerated by most employers. Or let's say the judge says this individual needs to be able to take an unscheduled rest break because of medication side effects and pain for up to 45 minutes 3 times a week. Again, this is a functional limitations that would make your RFC one where it's too restrictive to allow for any kind of job. So, what the RFC or the FCE forms, I call them functional capacity forms, what they do if you get your doctor to fill one out is you're asking the doctor to translate the medical findings into specific work limitations. Again, might be needing to take an unscheduled rest break, not being able to use foot controls. It could be being off task for 15% of the day, missing 3 days of work per month. And there's a whole list of things on FCE forms, and many of them, look, the one that I see a lot in wins cases quite often would be the total amount of sitting, total amount of standing and walking. Well, if the total amount of sitting is 2 hours, total amount of standing and walking is 2 hours, that's 4 hours, or let's say 4 hours sitting and 2 hours standing and walking, that's 6 hours. That's not a full day. So that limitation in an FCE form, if a judge accepted it as being representative of your capacity, would disable you. So getting these forms, you're asking a doctor, ideally a treating doctor, to make a functional assessment of your capacity for work. And the more restrictive that is, the better, assuming that it's consistent with the underlying medical record. Many judges find these FCE forms very, very persuasive. I had a hearing yesterday where my client has some significant issues that were not really discussed that much in the record, but she does get treatment for this particular issue. And so the judge nicely, very, very kindly said, okay, I'm going to give you 2 weeks, see if you can get me a medical source statement or FCE form from the person who would know about the particular limitations, and I'll consider that. Basically, what he's telling me is he's going to approve the case if we can get the therapist or doctor or whomever to fill this form out and to identify specific and invasive and work preclusive limitations. So RFC is a really important concept, and ultimately, what you're trying to prove is that your RFC has so many restrictions in it that it would not allow for competitive work. So getting a form from a doctor, while it is not guaranteed anything, it can be very persuasive. And at the very least, the judge would have to explain why he or she is disregarding an RFC assessment or an FCE assessment from a treating doctor, somebody who knows you, who's observed you over time, and who knows your medical situation. And some judges will try to get around that, or they'll say that this is not consistent with the record. But many, many times, a judge will look at that form and say, well, that's pretty compelling evidence, and we'll use that to approve your case. So again, when you prepare for your hearing, think about it in those terms. Residual functional capacity. The important part is functional. How your functioning is affected. And the other thing I would tell you to look at is the state agency level, which is where you were, and this is where you were denied at the initial and recon. Those determinations are going to be in the A section, A as an alpha, of your file. And look at the A section of the file, and I look at that and see what did the state agency adjudicator find. And for example, if they found that you cannot do your past work, but you have an RFC for a limited range of light work, okay, now you're already starting from a point where, again, the judge doesn't accept that, but it's already been determined by Social Security, presumably twice. So you could make an argument, look, the state agency found that I or my client is limited to an unskilled light work. So we agree with that, but we think they didn't go far enough. Now, sometimes the RFC and the state agency determination will be that this person can return to past work, or they have capacity for medium work. And again, you got to get past that. But it's always good to look to see what the state agency has already done, because you can make an argument that they, if you don't like it, you can say ignore it. But if you do like it, you can say that's our starting point. Again, judges don't have to do it, but many times they do, because I think that they would have to explain why they're not accepting what Social Security's already made a determination about. And like I said, they might, but I find that many, many times judges will use, it's rare, let's put it this way, it's very rare that a judge will look at a person's, make a determination about their RFC and find it to be, less restrictive than what the state agency already came back with. So use the state agency's findings to your advantage, if at all possible. At the very least, put it into the argument. I put it in my briefs, and I still make the argument that the state agency didn't go far enough. But put the burden on the judge to say, no, I don't want to buy that. And again, my experience is that very rarely happens. So, but yes, Sarah, get an FCE form if you possibly can. And I think I've told you there are places you can go. Let me put a couple of them in here. There's one fellow named, I think his name is Mike Marburg, who's got a, here it is. Oops, that's not it. Let me see if I can find it for you real quick, and I'll put it in the comments here. Or if you just want to look it up, you can look up Mike Marburg, M-A-R-B-U-R-G, I believe, and he's got functional capacity forms. And for some reason, I can't put my fingers on it right now, but if you look that up, there are free forms that he has put out there to his credit, and some of them are not new, but they are useful. There's also another one. If you go to How to Get On, let me find this one here. And I think the lady who did this has passed away, but she actually commented, she referenced me a couple of times. So anyway, I'm there's all this stuff is here. I don't want to spend my time and your time going through this, but look for Mike Marburg FCE or RFC forms, and he will, again, they're free, and that would be, I think, something you might find kind of useful. All right. Angie, does anyone know why the electronic folder keeps giving an error message for the last week due to the shutdown? SDDS had no clue. I don't know. When you say the electronic folder, is that at your My Social Security site? I would say this may be an area where if the government has IT people, they may be on furlough, they may be laid off. So it may be that there may be parts of their system that are not being updated. And so it's very possible. Now, I file things on the ERE, the Electronic Records Express. I'm downloading files, many times a day. I've not seen that issue. So maybe it's in the My Social Security part of it. I don't know. But on my end, the ERE has not been an issue at all. Trish says, hello, Trish. Hope you're doing well. Okay, Cowboy. Angela is a call screener in my office, so very good. We are looking forward to working with you. And I have to, what we do is when leads come in, I use a program to kind of get them, identify the cases I think have merit, and I send it off to one of my call screeners to make the initial call. Because I'll be frank with you, I get on the phone, and when you call people, they're not there, you leave messages. And so, many firms like me, we have people that we train that I call them call screeners, and they do the initial assessment. And then what typically happens is they'll report back to me, this is what this case is all about. I will then, so let's go ahead and take it. And then once we start the process, then Jen and I will be in touch with you. But, so a lot of times, I rely on my call screeners based on what I've seen and kind of the feedback to go ahead and get the process started. And then, as we start to get into the case development, then I, get on the phone and we'll talk about it. So in fact, I even use something called Calendly, where they'll give you the link to get on my calendar. So we will be talking soon. Okay, Vince is in Michigan, told me about Moomer's ice cream in Michigan. It's getting chilly there. I was in Traverse City, Michigan this summer, picked some cherries, and went to a wedding up there, or out there. I guess it's north of me, so I guess it's still Midwest, but it's up there. My buddy, I have one of my tennis buddies is from Detroit. He just got back from Detroit. So this first time I've ever been to Michigan. It was really pretty. I didn't realize Traverse City was such a long way from Grand Rapids. It was a couple hour drive, but we had plenty of good food and some Moomer's ice cream, and all was good. That was good. But Vince, good to see you here. I'm hoping we can get your case, gets to a hearing soon. It's been a while, I think. Suki Glass, what should you expect for a CDR? You have it next year. Will filling out the form be enough? Well, again, Suki, when you say you have it next year, is that because your decision said there's going to be a review in 3 years? My understanding is that with the shutdown, all the reviews are sort of been halted for the time being. Um, just because your decision said you're going to be reviewed in 3 years or 1 year, a lot of times it doesn't happen, or doesn't happen in that time frame. It may happen 4 or 5 years from now. So question one is, you say you have it next year. So that says to me that it's not even been started. But what'll happen is you'll probably get the long form, which I'm not sure if that's 454, 455, but you'll get the long form. Might as well tell you, SSA 454 is, I believe, the long form. Let's take a look here. Yes, that is the long form. And if you just type in SSA 454, what you might even do is go ahead and start working on that now. That way you've got it ready if you do get it, and you can update it as you need to. I will tell you, the biggest thing that they look at is, are you getting ongoing treatment? Does your doctor say you still continue to be disabled? So, continue to go to the doctor, go ahead and start the form. At least that way you can, when you have to actually fill it out for real, you're familiar with what the form asks, and you're already starting to get that information. But a lot of it's going to be medically driven, what the doctors say. So hopefully you won't have to deal with it for a while, but maybe it's next year, but maybe not. Far away is 40. ME, chronic, when you say ME, I'm not sure what ME, chronic fatigue, I'm guessing, since 2020. I just want to make sure we're talking about the same thing. When you say ME, let's stay with that. Let's see what that says. Okay. Myalgic encephalomyelitis, is what that is, which is an illness characterized by fatigue, muscle pain, other symptoms. Okay, I see what you're talking about. In fact, the CDC has a whole section on that. Some of these chronic fatigue conditions they give them different names. So I typically see it as CFS as opposed to ME/CFS, but regardless. Still lack a formal diagnosis, not believing patients will focus on the symptoms be enough. I will tell you, you're 40 years old, which puts you as a younger individual. That makes it more difficult. I think that not having a firm diagnosis also makes it more difficult. I have won cases where there is no clear diagnosis, but the symptoms are acknowledged by the doctors. But I think many doctors are a lot more comfortable with a name, with the diagnosis, and then saying the symptoms are consistent with that. So this is a tough one, because at 40, you've got an uphill battle anyway. And I think that if you're going to go into the disability world and you're focusing only on symptoms, you don't have a formal diagnosis from the doctor, which suggests the doctor may not find the symptoms. What are they consistent with? The doctor can realize that your symptoms are subjective, means this is what you experience. It's much easier if you have the wrapper of a diagnosis with it. So I think that's going to make it more of an uphill battle. So I would say a 40-year-old with undiagnosed ME, chronic fatigue, that's going to be a real uphill battle. I think your case would be a lot stronger if you had a formal diagnosis of ME, CFS, even more so if you had a specialist who deals with this condition, who could, take you through the standard treatment protocol. And I think having a functional capacity form would be almost an essential with something like this. This goes back to the days when, fibromyalgia was very, very common. I know it's still common, but when it was becoming a real known thing in the Social Security world, again, this is going back many, many years. And judges are cynical people. And, when somebody comes and says, yeah, I got this problem, and I'm fatigued all the time, and I feel sick all the time, but they don't know why. I don't have a formal diagnosis. There's nothing that they can do to really help me. You know, is a judge going to buy it? Some might, but I would tell you that there's a lot of scrutiny on judges now for approving cases when there's not a firm diagnosis. So I think, again, without a diagnosis, without an FCE, without specialist care, real uphill battle. I'm sorry, Farway. I think you got a real challenge, in my opinion. Pricey Joy tells Essay, this is the person who's asking about ECT. Pricey Joy had it. It's scary. It shot your short-term memory to hell. On the other hand, if it doesn't work, it'll help your case. Yeah. I mean, certainly it is a second line, third line treatment that's pretty significant. I mean, if you're taking ECT, they're shocking your brain, and it doesn't work, that is a pretty good indication you've got treatment-resistant depression. So I think that would probably help your case. And the fact that you've gone through this, it's kind of like a person who goes through a multi-level disc fusion and doesn't come out any better. A judge would look at it and say, you've tried everything possible and it still didn't work. That says to me that you've got a pretty significant problem. So I would agree it would probably help your case if it doesn't work. But at the end of the day, you want it to work. You want to get get yourself in a position where you're able to function more and have a better quality of life. But yeah, I don't know that I would undergo ECT. What I'm getting at is, don't let your Social Security disability claim or your thoughts about filing a claim drive your treatment. Your treatment needs to be based on medical necessity and what makes sense for you and your doctor's decisions on that. Don't make medical decisions because you think it'll help your Social Security case. I think that's really not a wise thing to do, because you just never know what Social Security will do. All right, Khalil Katana gives me a wave. Hello. Kiana Marini. Hi, everybody. Hope everyone's doing well. Diagnosed with CRPS, chronic regional pain syndrome. Over 5 years ago, my current doctor is saying can no longer treat me. Will this affect your CDR? So I'm assuming, Kiana, that you have been approved. You've been going to a doctor. CRPS, if you don't know, used to be called reflex sympathetic dystrophy, I think is what they called it, RFS or RFD. But anyway, it's a chronic pain condition. And essentially what it means is that you might have an incident where you have, let's say, damage to your hand or damage to your elbow. But for whatever reason, your unique nerve system causes what's a relatively minor or moderate type of injury to give you an extremely high level of pain. My wife, who does workers' comp, she sees that people have an injury, let's say, a hand injury, a crush injury, and the pain just sort of takes over the entire arm. And it's very real. There even sometimes there's heat, there's change of color, sometimes of the flesh. But it's just what's happened is that the body has just reacted to this insult, the trauma, in a way where you have this chronic pain. And it's recognized as a legitimate condition. And there's not a lot, quite frankly, they can do. I mean, they'll give you Neurontin, which is a nerve pain medication. They'll give you other pain medications. But at some point, many people just say, you know what, the pain medication just kind of masks it. It doesn't really help me very much. And the only thing that gives me relief is, whether it's cold or heat or just not using the body part. And I'm just, basically just survival mode. And so sometimes doctors will just sort of get to the point where they're like, I can't really do anything for you anymore. I can't treat you anymore. There's nothing I can do. And, if you have a CDR, continuing review, and you don't have medical treatment, that can be a problem. So what I would tell you is, if the doctor can't treat you, and again, you didn't say why, but, presumably it's because nothing he's doing, or maybe what the doctor suggested was something that you didn't want to do, maybe some sort of a pain management, maybe minimally invasive procedure or some other medication that you didn't want to do. And so he's like, you're not being cooperative and I'm getting rid of you. Or maybe insurance changed. I don't know. But my point would be, you probably need to establish a relationship with a pain doctor, pain management doctor, and make it very clear from the outset that, you're not going to do certain things, but you want just to be observed, just to have a record, once, maybe twice a year. And you can flat say, because Social Security, I'm on disability because of this. And if they don't see I'm seeing a doctor, that's going to be a problem. And so I would just like, just in in the event something has changed, and B, to show Social Security I'm still seeking care. I think that would be very, very useful. So the answer to your question is yes. I think if you don't have ongoing, and again, twice a year it can be ongoing medical treatment, that can be a problem in a CDR, because Social Security tends to view these things somewhat mechanically, meaning that if you don't have treatment, then they typically equate lack of treatment with lack of problem. So you need to have something going on there. It can be a neighborhood, free clinic or sliding scale clinic. It can be, just seeing a doctor once or twice a year. I could theoretically it could be the emergency room, but I wouldn't. That's not as ideal. But yeah, I think if you could establish a relationship, that would be with a pain management doctor. That would be helpful. Okay, Focus Lady asks a very, very good question. When Social Security sends a letter saying that you must contact them or the benefits will stop, but they don't answer the phone, is a fax sufficient evidence unable to go? I think so. I mean, I think that, if they want to answer the phone, what I would do would be I would fax, and I would fax multiple times and go to ssa.gov/locator to get the fax number of your local office. I would fax multiple times. I would do it 7 days or 5 days in a row, 7 days in a row, just saying, I'm trying to reach you. No one's answering the phone. I'm available. Here's my number. Please call me. I'm not ignoring you. I'm trying to cooperate with you. I would send a letter, certified mail return receipt requested. Is that going to stop them from cutting you off? No. But, it's very possible that gets in your file, and that would at least down the road, if you had to appeal that and the grounds for termination where you are not responding to their request for information, you can point to the fact that, save their fax receipts. I faxed them 15 times that I'm here. I sent them a letter. Here's the certified receipt, little green card. I think that would give you some level of protection, but I wouldn't just fax one time and think, oh, that's going to be enough. I'd fax them 10 times because sometimes you got to do that because they just, they lose stuff, and that way, and make sure you have the receipt showing the fax went through. Okay, Pricey George is asking the same question of Kiana. Why can't he treat you? Maybe Kiana will tell us. Okay, Teresita says, thank you, my pleasure. Do your SSD deduct your workers' comp settlement monthly pay if approved? I think it's called really more of an offset. So if you get approved for disability, you've got an ongoing comp case, they're going to want to see, the evidence of what your comp is paying you, and they will reduce your Social Security by the amount, of your workers' comp. Most of the time, there's some very specific rules probably about how this all works, but generally speaking, if your workers' comp is higher than your Social Security, then they're going to offset the Social Security. So they're going to ask for that paperwork, and yes, they will reduce your Social Security many times, eliminate the past due benefit, a lump sum. Okay. Calling fax local. Yeah, again, faxing, but just don't do it once. Don't do it once. Okay, Corlil says, well, aren't there 2 senators in New Hampshire? Is that where Bernie's at? So, I'd still contact him. I mean, honestly, when you contact your senator's office, it's not like the senator, I'm in Georgia. So, John Ossoff's not going to get on the phone. Raphael Warnock's going to get on the phone with Social Security. They have somebody in their office do it. Although I will tell you, one time, this is going back many, many years, I get a phone call from a senator, directly from the senator. It was either North Carolina, South Carolina, or Tennessee. And this guy gets on the phone. I can't remember his name. I can look it up. I can't remember what it was. I think he's not there anymore. He was not very nice. He was quite rude. And he's kind of berating me. Why is it taking so long? I may have told this story before. I just said, well, Social Security has long delays. I said, that's kind of your problem. You're the senator. They don't have enough money to hire the people. That's really more on you than on me, wouldn't you say? And he kind of growled at me, do what you can, and hung up on me. But, it's pretty rare that a senator gets involved. And maybe if you are, a relative of a big donor, you might get a call from a senator, or maybe the senator has got nothing going on that day and he decides he or she is going to pick up the phone and call somebody. But generally speaking, it's going to be a staff member. But you know what? We elected them. We pay their salaries. They have some pull. Use it. I would tell you, most of the cases I've told my clients, contact your senator to get this speeded up. And most of them say expedite case for that. So, yeah. Okay, talking about assuming you're talking about Bernie Sanders. Okay, Tara. Hey, Tara, you've got a new screen name, don't you? But anyway, good to see you. I hope good to see one of my clients. We got her approved administratively. Pricey Joy. You're from the New York suburbs, and really you don't talk like that. My wife is from the New York suburbs. She was born in Queens, and it comes out every once in a while. Her dad, who lives here, has a very thick accent, and it has not gone away after many, many years. But confirmation. Christy says, good evening. Good evening, Christy. Is the appeals council in federal court being affected by the shutdown? No. Nope. It is not. Okay. All right. So Pricey Joy and Focus Lady are having a conversation in the chat. So we'll let them have that conversation. Cowboy Up. Am I disabled at vision of 21 it's not the grid rules, it's the listing. The listings basically say there's a listing for special senses and speech. I think it's listing 2, if I'm not mistaken. And I believe that 2200 in the better eye would meet the listing, but 2100 is still pretty significant. Again, I'm assuming even with correction. 2200 would be listing level, generally speaking. I mean, there are a few more things required of it, but if you're 2200, you're pretty much not able to see well enough to work. But 2100, I think, could probably eliminate jobs that require any sort of reasonable visual acuity. 2200 is listing level, so it's not 2100, it's 2200. Okay, Roy. Is it better to give the medical records in person during the SSD application, or let Social Security obtain them? This is a question, as you may remember, I had a guest on a couple of weeks ago. It was a person, I think she went by Linda, who is a current Social Security adjudicator. And she didn't want her name mentioned because she's still there. And I asked her this very question, should we as attorneys or should claimants submit their medical records? Her response was no. She felt like that, if you submit records, it's going to probably not be the full record. So when they request them, which they've got to do anyway, they're going to have to go through and deduplicate it. That's extra work for them. And what she said was that if we're having trouble getting the records, we'll call the attorney, we'll call the claimant and ask for help. But they don't want it unsolicited. I think the second thing, and she didn't say this, but I know this to be true, is they're concerned about people going in the record and taking out pages that maybe talk about things that are not helpful. This person maybe has smokes marijuana or had a drug issue or whatever it may be. Or this person went motorcycle riding one day. And these things may or may not be relevant, but I think they're concerned that people are going to, I call it scrub the record of things that are not helpful, and they don't want you to do that. So they generally want to get the records themselves. Now, my caveat, my exception to that would be if I'm looking at a I use a couple of different programs. One of them that I use is called Chronicle, and it kind of shows me what's going on in a case in real time. If I look on Chronicle and I don't see any activity in a file for 3 or 4 or 5 months, then that A would prompt me to contact the adjudicator, or B, we might send records in at that point saying, you're not really working this case. Here's some records you need to consider. But according to my guest a couple of weeks ago, they don't really want people to send it in. That just slows the process down. They've got to get them anyway. They want to get them. And they now, with the health information technology, or the HIT process, they can get them pretty much immediately just with a click of a mouse. So they'd rather have that. Another issue that you run into is many people get their records from patient portals. And patient portals, the formatting of the record is different than a, quote, real medical record. So it can be hard to read. It can be hard to really know what you're seeing. It can be hard to separate that out from the other records there. So what it boils down to is let them get the records. I don't know, I would, if you have records, keep them available. You may need to send them in. If you get the sense that nothing's going on, you might want to send them in. But generally speaking, let Social Security get the records. That's what they're telling me. That's what at least Linda told us. Yeah, I think Pricey Joy is correct on that. I would agree. On an earlier question, I know I'm not required to undergo ECD, I'm required to have the consultation. I probably would. I think I would go and just find out. That way you can say you did your due diligence, find out what it's all about. And that way you can say, I researched it and I went to the consultation. And then when they told me all the possible bad things that can happen, I decided not doing it. Is it absolutely necessary to go to the consultation? Probably. No, not absolutely necessary, but I think it would probably be helpful and enhance your credibility. Okay, did I get approved for my SSDI back because in 2023 I was diagnosed with a cervical cancer, recently came back? Christy, I'm not sure if I understand your question. Did you get approved because in 2023? I just don't really understand what you're asking me. If you could rephrase it, I would appreciate it. Yeah, I think you should go. That's right. I would go to the consult, but that's what I would. That's what I would do. I would go at least. You're not a lawyer, Pricey Joy, but you play one on TV. So you know what? A lot of law, not all. I'm going to tell you, not all, but a lot of law is just common sense. Just realize that judges are human beings, and from their perspective, they see people all day long, every day, that say, I'm disabled, pay me. That's why if you go into a hearing or deal with Social Security as a reluctant claimant, I don't want to be here. I'd much rather be working. I'm going to do everything I can to make myself better. That resonates. That's such an unusual attitude from what the Social Security, decision-making personnel usually see, that I think that can really set you apart from other claimants. So I think if you go with the idea that you don't want to do this, you don't want to be here, that can help. And I think if you go to let's say in this case, if this person goes to the ECT consultation, here's out what they have to say, here's what they have to say, then makes a decision, this is not for me. A judge looking at that saying, wow, you considered having your brain shocked by electrical current. You decided not to do it, but at least you did your due diligence. I think common sense, that just makes life, makes you look better. That's what I think. Okay, my ALJ is, let's see what Helen Valkovich, let me pull her up again. According to this one website I'm going, that her approval rate is 41% fully favorable, 18% partially favorable. I think what I had said to you the other week was, that says to me that with an 18% partially favorable, that she's changing the onset date. That if you're, let's say, 55 now, and you turn 55 in January, and your onset, you were 53, she'll approve you, but she'll approve you at your 55th birthday. Again, I don't know anything about your case. I'm just saying that when I see that high of a partially favorable rating or percentage, that says to me the judge is changing the past due benefits. Does that make sense? In other words, if you applied and let's say you allege your onset date was 2023 when you were 53 years old, your hearing is now you're 55 and you turn 55 in January, the judge could say, yes, I'm going to find you disabled, but I'm going to find you disabled as of your 55th birthday using that grid rule. Or I'm going to, whether it's maybe the grid rule doesn't apply at all. I'm going to find you disabled, but I'm changing the onset date to, March of 2025. Well, you get future benefits, but there won't be any past due benefits. And some judges, for some reason, like to do that. I don't really know why, but you've got to make a decision. And I have this conversation with clients all the time where they get approved and they change the onset date. Do we appeal it and risk going to a hearing where you get nothing, or do we appeal it and hope we get the earlier onset date? Every time I've done it so far, I've gotten the earlier onset date. And a lot of times I tell my client the real risk is you go to a hearing and you get the same thing. They just put it at that 55th birthday. So sometimes I'll say there's not a lot of risk. Let's go for it. If it's $100,000, it's probably worth taking the roll of the dice a little bit. I would, like I had one the other day where my client was approved and they changed it by 1 month. And I said to him, do not appeal this. There's just no reason to appeal, a change in the onset by 1 month. It's just, why would you do that? It's just not worth not worth the risk. Christy says, thank you. Welcome. KU Thunder. We emailed the other day. Hello, and does the denial factor a lot in second application not following the grid rules initially? We do now. The only thing I would tell you is when you had a prior denial, especially if it's at a hearing level, usually that my experience has been that the state agency adjudicator doesn't give it a lot of attention. They just typically deny it again. Now, the fact that you now are in an age category where the grids apply, you'll probably get a more thorough look. But it's not binding. I mean, realize that when you start a new application, your onset date is going to be the day after the hearing denial. So you're not asking them to revisit what happened 4 years ago. You're saying, as of the date of the hearing, that's my new onset, or the day after the day of the hearing. And so let's look at that with a fresh pair of eyes. That's what they're supposed to do. But yeah, they're aware that there's been a prior denial, but I've had many hearings that I've won when there was a prior hearing denial when the person was younger. So age is a big factor right now that could benefit you. Sarah says, thank you. Very welcome, Sarah. If a person has an IQ of 60, is that a good indicator? Well, that's going to eliminate, almost on its face, a number of skilled and semi-skilled kind of jobs. Let me just pull up my listing site. There is something in there, and I haven't used it in a while, but I've argued this before. If you look at listing number 12, and let's see if I can find it on the 1205 here. Okay, so listing 1205, let me just share my screen so you can see what I'm looking at here. Okay, here we go. All right, so this is listing 12.05. And so basically it's called intellectual disorder. And if you look at this one here, it says a full-scale IQ of 70 or below, and significant other type of issues. So many times so my point is that an IQ of 60, which is below 70, is sort of like you're halfway there. As long as there's some sort of a functional deficit that arises from that, inability to understand simple directions, difficulty behaving in an emotionally stable manner, not being able to interact with coworkers or supervisors, maybe some sort of, anger control thing. I mean, not that people with low IQs have anger control, but maybe not understanding social cues, I'm just throwing off things here. But my point is that, if you've got some functional issue that is related to the low IQ, then I think that that gets you into listing level territory, 12.05 in particular. Or in an alternative, you could say that, with this low IQ, at a minimum, this person is limited to entry level 1 or 2 step unskilled type of jobs. Maybe you have something physical, you get the grid rules to apply. Even if not, I think that you could certainly say that there's very few jobs out there that a person with a really, really low IQ, very poor cognitive capacity can do. There was a lot of discussion on the NOSCR. NOSCR is our sort of trade organization listserv, which is, I look at it all the time because that's a lot of attorneys who do this. We're all talking back and forth. There are a couple of people on there who are adamant there is no such thing in 2025 as a really unskilled job. I mean, every job, there's complexity to it, whether it's using a computer, using some sort of a device, a cell phone. There's always things that you have to, some store of knowledge you've got to have to do any kind of job. Even cleaning jobs, which are typically unskilled, you might have to use some sort of a computer keypad to unlock a closet, or you to disarm an alarm. And as silly as it may sound, that's the sort of thing that if you have very, very low IQ, you might not be able to do. So at a minimum, some of my colleagues feel like there are no truly unskilled jobs, or others say that the number of truly unskilled jobs is much, much lower than what the Dictionary of Occupational Titles says it is, because the DOT was last updated in 1990s, so it really doesn't reflect reality of today. Long story short is, answer your question, Roy, is yes. I think that a person with an IQ of 60, there are a lot of things that would make that person difficult for that person to find a job. There are very few jobs a person with that level of IQ can do without being in a structured work setting, meaning that somebody's there, just helping the whole way. And like Goodwill has structured work settings, and there are programs for people with low IQ to give them in the community to be able to do things, but they have folks that are helping them because they can't handle change in routine, or they can't answer questions and things like that. So anything outside of a structured work setting, I think that a low IQ like that would certainly be a factor and a good indicator of disability. David Clark says, "Can I recommend a good?" David, I don't really know anything about the ticket to work. I just don't deal with it at all. That might be a question for what's the guy's name? There's a couple of people I'm thinking of. Ed, let me get his name for you. Ed Weir, WEIR, ed at mygovernmentexpert.com. That might be somebody to talk to. There's a couple other people that are out there, but Ed might be a good person to talk to about that, because he answers questions like that about ticket to work. I think it's just, like I said, I don't know much about it really, so I just can't really comment on it. What factors does SSA use to update the Blue Book when they update every 2 or 3 years? Asked Christy. I don't know. I've not seen it published what they use. I suspect that they're looking at, advances in medical technology, different types of treatment for different types of diseases, rehab and recovery for different kinds of diseases. If there is, I'll give an example. Back when I started doing this work 30 something years ago, diabetes was a listed impairment. If you had diabetes that was out of control with retinopathy and neuropathy, you could be found disabled based on that. Well, since that time, we now have insulin pumps. We have continuous glucose monitors. The technology has evolved such that diabetes, while it's still dangerous, there are many more ways to control it and to monitor it than there were 30 years ago. So I think Social Security saw that. They saw some of these different treatments that came along and the glucose monitoring and all that and insulin pumps. And they changed the law to say, we don't think that this is a listing level impairment. Now, I have a lot of clients with diabetes that's not controlled, even with the monitoring and so forth, and that can be a factor. And if they're, in the case of diabetes, if your blood sugar is out of control for a long period of time, years, you can develop the retinopathy, which is the blurred vision and damage to your eyes. And you can develop the neuropathy in your hands and your feet. But the fact is the technology has changed. I suspect they look at, what the technology will allow for. I know that there's, many, like with knee replacements, hip replacements, there are, titanium, um, uh, you know, body part replacements that can be installed that, I have a buddy of mine, one of my tennis buddies, he had a hip replaced a couple of years ago. We play tennis. I mean, he goes, my replaced hip is much more comfortable than my other hip. So, but 30 years ago, that wasn't very common. I know, my wife's grandmother had a hip replacement back in the early 60s, and she was in a full body cast for like 3 or 4 months. So technology changes. So I would think, Christy, that they're going to look at the technology, what type of treatment is out there that would allow for, better results, better control, less time off, and that's what they use. I think there's also a political component to it, meaning that, the people in the Senate and the House, they look at Social Security and they say, well, we got all these people that are saying they can't work because they're depressed. So they pressure Social Security to make the depression listing, or the depression standards a lot higher. Back pain is the number one reason people file for disability. So they changed the back pain, the musculoskeletal listing a few years ago to make it more difficult. Why? I think it was politically motivated because politicians are seeing money going out the door for people with bad backs and Social Security, and they're trying to preserve the trust funds. So rather than, how do you do that? You make health healthcare more accessible. That's expensive. Now let's just make the listing more difficult to meet. That way, fewer people will qualify. That'll save us money. That'll preserve the trust fund. That's what they do. So I think there is medical technology and political reasons is my my take on it, how they changed the Blue Book. Tip says, my doctor wrote a letter and said I'm unable to work again. Also give me a handicap sticker. I think that was, pardon me. This is bubble water, club soda. That's why I just did that. Excuse me. I think it certainly helps, but realize that, if you submit a letter and there's no treatment records from that doctor, Social Security won't give it a lot of weight. If you submit a letter and your ongoing treatment records do not reflect that level of limitation, that you can't work, that's going to be an issue. So, it's got to be consistent. Judges are allowed to disregard sort of conclusory statements. You're not able to work unless it's explained in the context of your medical problem. Same with a handicap sticker. That is evidence that a doctor felt like you're deserving of a handicap sticker, but that is not an assessment of your medical condition and an explanation as to why you're disabled. Do those things help? Yes, because I think adjudicators and judges realize that, doctors have to be careful about handing out handicap stickers. They're not, if I went to my doctor and said I want a handicap sticker, he's not going to give it to me, or a handicap placard. He's not going to give it to me because I'm not handicapped. And so, I don't think that most doctors are going to give these things out unless they feel like there's a reason. And realize doctors, you may find this when you're talking to doctors about disability. Many doctors are concerned and reluctant to, encourage disability because they don't want people giving up. They feel like, you need to continue to try to search for treatment, search for a resolution, as opposed to saying I'm disabled and giving up. Now, I don't think it's giving up, but I know some doctors are just going to, be reluctant to support you in that regard. But I think that, having anything from a doctor that reflects disability is good. Even better would be an FCE, a functional capacity evaluation trip. P. Brown, one of my new clients, local SSA doc, sent my documents to DDS. Can you please tell me what I can expect next? Well, I mean, assuming that the DDS is not impacted by the budget cuts, what's going to happen is now the case is going to be adjudicated. That means that the state agency is going to assign an adjudicator to it. That person will take whatever forms you filled out or whatever documents you've provided them. They will then request medical records. And that process can take 6 months. It can take 4 months. It could take 12 months. It just depends on how busy the state agency is. And so they're going to be gathering medical records. They may send you additional forms. And I've got videos about how to do those forms. And I always tell my clients, if you get a form, I don't like to fill them out because I think that's evidence. But if you want me to look at a form that they send you or ask you to complete, I will look at it, give you my thoughts, observations, suggestions. You could redo it. A lot of the forms are available online. So many people send me their forms. I review them and get back and say, I don't like the way you worded this. You talked about, for example, I can't lift very much at all. I want you to be, I can't lift more than 10 pounds or 15 pounds or whatever it may be. So I'll give you constructive feedback on the forms once you start getting them. And, you can assume you're going to get certain forms, activities of daily living or disability report, or sometimes a pain questionnaire, depending on the underlying issue. But I think what's going to happen now, the two things are going to happen now would be, one is that the medical records are going to be gathered. Number two is you're going to get some forms from Social Security where they're asking you to kind of breathe some life into the underlying issue. And again, I'm happy to review whatever forms you get and assist in getting them to the point where they are, as compelling and convincing as possible. And welcome aboard, by the way. Christy says the letter won't help, has medical records. So I think what Christy's saying, and I agree, a medical record or letter on its own without underlying medical records is not going to do a lot of good. But if there's underlying medical records, you've been seeing this doctor, this letter is kind of a summary of what the doctor is thinking in terms of your capacity. I think that would help. SA was the person who asked about ECT treatments. For clarification, if someone has to get ketamine or thorazine for treatment-resistant depression, what do you, if your psychiatrist says they don't have any more options? Let's see what else we got for SSD purpose. What do they do? All right, so ketamine and thorazine and some of these, ECT, some of these second-level treatment options can be inherently dangerous, and they can also be expensive, by the way, too. Treatment-resistant depression suggests that treatment is not working. I think that generally refers to the first line of treatment where it's going to be medications, Prozac or Paxil or whatever the medication might be. And I think that if you're tried on 4, 5, or 6 medications, nothing really seems to work. You might get that label of treatment-resistant depression. I don't know that you have to go to the ketamine route to get to that, though. Okay, David Clark says just awarded SSDI due to cerebral palsy, I'm guessing, stopping filing for unemployment because I was told not to collect both. That's an interesting question. There was one point in time many, many years ago where judges were asking people, are you collecting unemployment? And the judge would say, well, you're saying you're ready, willing, and able to work. How is that consistent with disability? And my response when I coach my clients to say was, I said, I'm ready, willing, and able to try to work. And I am. Doesn't mean I can do it. The trial work period, unsuccessful work attempt would be 3 months or less, or 6 months. I think it's not 6 months. So saying I'm ready, willing, and able to try to work does not mean I'm medically able to work. It means I'm willing to try to work. So I don't see an inconsistency there. Now, you might be concerned, David, that if you collect both, you may be, treading on thin ice. I personally don't. If someone was to ask me, I don't know that I would give up unemployment because you're still, Social Security wants you to try to work. So, if you're willing to try to continue to look for work, that's not inconsistent with Social Security at all. On the other hand, do you risk bringing attention to yourself by virtue of collecting both? Yeah, you probably do. So that's just a judgment call you got to make. But my opinion would be there's no inconsistency. That's just me, but I don't think there's inconsistency. Colorina. I was asked if I drove. I have swelling or edema in my hands and feet. They fall asleep periodically. I told her short distances. The judge says, can I say once a week? And I said, I guess. I'll ask my case. Also have taxi service. So I don't think you lost your case because you said you can drive once a week. That, if that does not make you not disabled. I have plenty of clients who drive 3 and 4 and 5 times a week. So, the fact that you're only able to drive once a week, it does not mean you're not disabled. I suspect there's other things going on there, other medical issues or lack of medical issues or lack of evidence. But driving short distances once a week does not make you capable of working, a full-time job. Pardon me. So no, I don't think that's a problem. I don't think that's a problem. That's not why you got turned down. I think there's other things going on. Pricey George says ketamine is worthless. Michael Myers has been Thorazine. I'd skip it. Psychiatrist suggests TMS. Never had it. Okay, I don't want to give medical advice on this live stream. No, Christy, that's not been neither. Easy for me to say. That has not been my experience. I've had plenty of people collecting both, or collecting unemployment than going for disability. Again, I've not had a judge ask about it. I've had judges even pointed out in the earnings record, what is that? That's unemployment. I think certainly during COVID, judges realized that people needed to find a way to make money or to survive. So I've not had that issue come up. Is it saying it won't come up again? No, but I've not had it come up. That's just my take. All right, Mr. Donnie Doomsday, denied a federal quality review on recon for IBS and spinal stenosis, nerve impingement, need help. Okay, so you went to recon and somehow got flagged for quality review and you still got denied. The next step is to request a hearing. I mean, that's where you'd reach out to an attorney like me and say, let's look at this and see whether we have a good chance for a hearing. I found IBS cases, if you have really uncontrolled bathroom needs, can be really, really strong cases. Spinal stenosis, nerve root impingement. A lot of this is going to depend on your age. I mean, you looking at your picture from your YouTube profile, you look younger. So if you're in your 30s, it's going to be more of an uphill battle. If you're in your 50s, much, much easier. Let's see. Pricey Joy and Christy are having an ongoing conversation. Pricey Joy hits the nail on the head. Laser focused on your inability to work, not a bunch of diagnoses. Absolutely, 100%. Well, I mean, if you need an attorney, send me a case eval. You see that? That's a review. Let me put the case eval banner down there. Okay. Just send me a case eval. I'll take a look at it. And, again, I would probably have questions, but, let's see what it looks like. Cowboy, it's 2200 generally speaking, or loss of visual acuity on some charts. Look at listing. Let's find it. Look at listing 2 and 2.02, 2.03, 2.04. Let me put that in the comments here. This is the listings you want to look at. I just put them on there. Okay. All right. Can I put a list to my website? Yes, I will put that. It's SSD answers. and that is my website, ssdanswers.com. So if you look also at the crawl at the bottom of the screen here, bit.ly/contact Jonathan3, that will get you to the same place. Okay, so here is Marburg's functional capacity. Let me just pull that Mike Marburg. I feel bad because I need to, wow. I'm going to find it because now it's got me ticked off. I can't find it here. I just saw it there. There are a lot of free ones out there. Okay. Here we go. Let me share my screen, and I'll put the URL in the, I think you already did this, but I'll put this in here again. And I don't know Mike, by the way, but I appreciate what he's done here. So let me just give you that. Let's share the screen a little bit here. And that is what it looks like. So if you go to Mike's website, and you will see there is a place that says RFC forms right here. He's in Tampa Bay, and you got a whole bunch of forms for free. So that's, and you can modify the forms, and nothing wrong with that either. So, but yeah, that's a good on Mike for sharing that. That's very nice of him. Prices, yeah, I don't want to talk about Ticket to Work because I just don't know anything about it. All right, here's another place where there's some free forms. I've not heard of this one here. Oops. I'll look it up though. Let's take a look here. This says disabilityattorney.net. Resources, forms. Oh, that's Mike. That's the same person. That's Mike Marburg. So same person. Mark, how are you doing, Mark? Absolutely, Mark. And I don't want to talk about your. I know, absolutely remember who you are, and I was glad to do it. And unfortunately, I know what you're dealing with. But absolutely, good to see you here, and hope John is doing good, because I know it was a struggle, but we prevailed. It was that was an interesting hearing. I think, if I'm not mistaken, both you and your sister testified on that. One of you did, I think, and the judge was the judge in that case, if I remember correctly, was at the hearing. We had a hearing, and the judge was really a pretty nice guy, and he saw him because I did a brief, and they saw my letterhead that I have YouTube videos, and he's like, I got to check out your YouTube videos. I got to wait till after I decide this case, but I'm going to check it out. So I'm hoping the judge did. But he was kind of a nice guy. I don't remember his name, but I could look it up. But interesting guy. So yeah, but good to see you, Mark. Hope all is well with you and your sister and John. Wesley Yancey, great. Wesley filed for SSD under the grid rules. You're approved. Received the back pay, direct deposit, 100 days. Yeah, I mean, the system can work. I mean, doesn't always work, but it can work. And so Wesley is an example of how it can work. I had 2 or 3 cases that I tried in September. The cases the decision was issued within a week. The money's been deposited. So it does happen. Not as much as it should. Okay, Ray says, person can't work full-time, only part-time. 2 answers to that question. Generally speaking, Social Security is looking for full-time work, but the bigger point is how much you're earning. If you're earning under 1620 or SGA and you're part-time, that's a good recipe. Now, again, you got to prove that's all you can do. But you can work part-time, but if you're doing so, you want to keep your earnings under the SGA limit, which again in 2025 is $1,620 a month gross. Okay, so people talk about the ticket to work. Oh, Price, you love Traverse City casinos. I don't gamble. I've been to Vegas. I've been to on cruise ships a couple of times. I just don't see the point. I mean, you're going to lose. I don't find it entertaining. I don't have the skill. I've never learned. I mean, I could play blackjack, but I've never really learned how to play craps or the other games. And slot machines are kind of a waste of time. I mean, I've been to Las Vegas a couple of times, and really the shows and the food, which now is not even that big of a deal anymore. I remember one time we went. My kids were young, and we went there because we were supposed to go to New York, and there was a blizzard. And at the time, the airlines Delta was very accommodating, so you can go any place you want, no change or no charge to change the tickets. So we went to Las Vegas. We stayed in the Venetian, which is a really nice hotel. And of course, the kids were young, so they couldn't go in the casinos. And we watched some shows. We saw the Beatles Love show, which was nice. We saw a hypnotist, which was really kind of cool. And by the way, if you ever see a hypnotist, sit in the back. Don't sit in the front because they're going to pick on you. So we saw the hypnotist. That was fun. And then we took a helicopter tour to the Grand Canyon. And I don't really have a problem with heights or helicopters. It doesn't bother me. My daughter is the same way. It doesn't really bother her. My wife and my son can't deal with it. My wife got so sick, so nauseous, and she was green with this helicopter. A lot of these guys that fly these helicopters for these tourist companies, they're former military, and they like to show off, and they're zooming up and down and all that stuff. And so we went to the Grand Canyon, and you land kind of in the canyon, and they bring out like some food and wine and cheese. And of course, my wife is like, I couldn't eat anything. I'm eating cheese and all this stuff and crackers because this doesn't bother me. And then we get back, and then we had to stop again to get some gas in the helicopter. And like I said, she was just so sick. She's like, never again. So that was our Las Vegas story. So it was, but it was, it's a fun place. If you've never been to Vegas, it's fun to go. It used to be the food was really cheap. Not anymore. I think it's gotten much more expensive. They kind of made it more of a family place. So there's a lot of stuff for people to do. One of these days, I'd like to go back and do a photo tour of old Vegas. There's, some of these old ghost towns, cowboy towns, but hadn't been in several years. But it's worth seeing. But again, if you don't gamble, like I don't gamble, a lot of the allures out. I mean, the casinos are pretty crazy. They're these huge, just absolutely huge hotels with all the, the bright lights and sensory overload. Of course, no clocks in it. They make you don't use real money, use cards and all that stuff. So it doesn't look like you're spending money. There are a lot of psychological parts to it. And I remember one time I was there, one of the times I've been maybe two or three times, and somebody decided to, and you'll see this, they took like, I don't know, $10,000 or $20,000 and said, okay, I'm going to on blackjack or whatever it was. I'm going to on the roulette, put it on black or put it on red. And, with roulette, you got, you have red or black, so half the numbers are red, half the numbers are black. And there's a 0 and a 00, which I think are green. So, if you put your money on a color, let's say red, it's a little bit less than 50, you'll double it. If you win, you double it. If you have it on red, obviously, if you put it on a number, the odds are much higher, but just doubling your money. So I remember this person came in there and they put down, I'm going to say it was $10,000. It may have been more on red. And I remember the casino, they had all these security guards, the guys with the walkie talkies and all that. They wouldn't let anybody take pictures of it. And the person spun it, and sure enough, they won. They doubled their money. It's kind of a risky thing to do. I mean, I wouldn't put $100 on something like that. But this person did. I think it was, like I said, $10,000 and double the money. So it can happen. So anyway, got a bit on a tangent there. But if you've never been to Vegas and you like to gamble, of course, be careful. But and they have casinos everywhere. I mean, literally, you go in the grocery stores, you go in the airport. Rodney Dangerfield had a joke one time. He goes, I went to Vegas and it cost me, $250 for a loaf of bread, because you go to you go to the grocery stores. There are slot machines in there. Some people can't. It's just an addiction. But doesn't do anything for me. Tammy Walker. Hey, Tammy. Okay. Credentials for interest. Yeah, I mean, I think you're doing anything you can do. I mean, 10 months is certainly long enough for them to do something. Hadn't been assigned. It's still in staging. Congressional inquiry, voicemails. Yeah, voicemails, they're probably not going to do very much. But the congressional inquiry, you'll get results on that. You'll get results on that. So just be a little patient. Be a little patient. I know it's easier said than done, but nothing other than that. You've done everything you can do. Christy, thank you, Christy. I appreciate that very much. And yes, please do like and subscribe and hit that bell so you get notified when I send out notices about this. I get new videos, all that. But yes, please do. I really appreciate that. I'm here pretty much every week. I was in here last week, but I'm here pretty much every week. And tell your friends. I mean, we're trying to let people know about it. And I have guests coming. I've got actually a very interesting guest coming up in a week or two. It's a woman who used to be a non-attorney rep. Kind of doing what I do, but she wasn't an attorney. And her name is Tricia, and she went to medical school, and she, took the time and she went to medical school, and now she's a medical doctor. And so I'd known her from years ago when she was doing, she was actually working for a law firm as a non-attorney rep, obviously bright woman. And she went to medical school. So I'm really interested to hear her perspective on disability process now that she's a medical doctor. So that'll be really interesting. That's coming up, like I said, maybe not next week, maybe toward the end of the month. But I'll get word out about that. But then I've got a couple other fellow attorneys, and we're going to get some of the adjudicators. Linda's going to come back on. I think Spencer Bishens used to work at Social Security. That was a great live stream with Spencer. He's going to come back on. So we're going to get some guests, and I have my normal guests. I've had some attorneys that come on here. Stephanie Joy is one of them that comes on, and I've had a couple other attorneys that come on that I think always give. Andrew, Bernard Blankness last time, he was on a couple of weeks ago. He's had some really good insight into some things. So there's a bunch of people we'll have coming on, and just try to make it a little bit different. Cerebral palsy, okay. Anyone else having difficulty logging into SSI portal? Something alarming? Yeah, I think it's just maybe the technical support is probably not being not there. I don't know, because interestingly enough, the way we have to submit our availability for hearings, we have to log into essentially my SSA. Although, and I don't really, there's a little bit different. I mean, the URL is a little bit different, but it's the same system, and it worked for me last month. So, but I will check. Now that people mention this, I'm going to check my own personal my SSA account and just see if I have the same problems you all are having, because I don't know. Aunt Scary Sherry denied at recon under the LJ. No, as far as the recon, if you request a hearing, you'll get one in 5-6 months. That's the one place that's been fast. So I think it won't be that long. Okay. Cowboy Up. One of two. Do medical source statements hold weight with SSDI reconsideration? Yes. Yes, yes, yes. Proliferative diabetic retinopathy? Yes. That will be a medical source statement. If we can get that, that's great. Yep. Inoperable due to low heart function and blood thinners, they can't operate for this another year or two. Yes, absolutely. We'll definitely want to get that in, because that is, they look at it. They have medical experts, medical people look at these things. And if you've got a medical source statement that basically says why you would not be able to work, then absolutely. Yeah, I was talking about CRPS, reflex sympathetic dystrophy. That's right. Jeff Brown says, and Jody's my wife, so I don't know if you know Jody, but I will tell her that Jeff Brown says hello. How about that? Phoenix, Arizona in the house. Thanks so much. 61 years, 40 months from application, LJ fully favorable. Kept me calm. You got it. You got it. Absolutely. Well, keeping my clients calm is not an easy thing to do, but we can get it done. We can get it done. Bottom line is, when we get that favorable decision, that's one of the most pleasant parts about my job. Is I send a letter. I have an email that goes out to my clients and says, I just checked and you won. And that's great. I actually had one a week ago where it was supposed to be on Monday. And I'm talking to literally, we're doing our pre-hearing call. And I get a call during the pre-hearing from the judge's office saying they're going to grant this case on the record. So I didn't even know this. And so I finished up my call, and then I get the message, and I call my client back saying, hey, we just won. And she was just, over the moon. It was great. So I love when that happens. So that's the best news of all. And even better when the payment comes, because sometimes there can be a little bit of a gap between getting approved and getting paid. Dimple Bellamy, chronic condition, have been getting monthly infusions, got to the point where I can no longer meet my work quota, decided to leave in 2 weeks instead of getting a pink sheet. 59.5, do you say proving over doing a prior job, skill level of 3? Yeah, I mean, that says to me that you are either a grid rule candidate. If it's physical, realize the grid rules only apply when you have physical limitations, back, knee, lifting, carrying, physical stuff. But if you're 59.5 and you can't do your past work, and you've got basically unskilled or really low-end semi-skilled SVP3. SVP, by the way, stands for specific vocational preparation. An SVP3 job is a low-end semi-skilled job. SVP 1 and 2 jobs are unskilled. So at a 3, that's pretty much unskilled. So you probably don't have any transferable skills. If you can't do that, and again, if there's anything physical at all to limit you to light work, I think you win. I think it's a good case. I mean, just based on your age and the you've been you can't meet production quota. You got a chronic condition. I think that all kind of lines up. That looks like a pretty good case to me. Kiana, thank you. Welcome. I've done previous treatments, got injured, pain management, physical therapy, had to be action of cortisone. So my current doctor doesn't know what to do, can't get injections, nerve blocks. So yes, I think it's just basically the doctor saying nothing I can do for you, but maybe you can get that doctor just to see you once a year, just for updates, to see if there's anything new on the horizon. That way you at least have some ongoing medical. All right, and Dimple, let's go back to what she said. Can't meet work quota. There's something that she said, been at the same job since 2013. Yeah, that's another factor. And the reason I wanted you to see this was when somebody has been working at a job for 10 years, 20 years, 15 years, that makes a difference to Social Security judges. They, because that says to them that you are hardworking and you're willing to work through discomfort and pain, and yet, it enhances your credibility, is what I'm getting at. Enhances your credibility. Okay. Our claim is taking longer. Yeah, I mean, I would say probably, and I don't know that the shutdown is directly responsible, but I know that with all the reorganization of Social Security, they have a lot of untrained people that are learning on the job, and therefore it's going to take longer. So I think that's probably more of a factor. Super LFG1 about the money, took a pay cut for sure, the validation can't work. Yeah, I think that that's a very, very good point. Is I think for a lot of people, having a judge look at this and say, you've got a significant problem. I recognize on behalf of the federal government, we recognize that despite your best efforts, you can't work anymore. You're deserving of benefits. That can go a long way to keeping your family happy. Obviously, the money is going to keep them happier too, but it does validate to some degree what you've gone through. I think that anytime you have a skeptical, difficult third party say, yeah, what you're talking about is not in your head, this is real, that can certainly make things better. I would absolutely agree. If you're ever in Phoenix buying lunch pizza, actually, I've been to Phoenix several times. We went when my kids were a little bit younger, we would go and I really like Phoenix. I think it's really nice. They have a beautiful zoo and a beautiful cactus garden there. Scottsdale, Phoenix, that whole area. And then we drove to Sedona. I'm sure you've probably been there. That's really very cool. I think we went to, what is it, Chompy's Deli was the I can't remember the name of it, but went to the deli. Yeah, I mean, I'll probably be out there at some point. So yeah, we'll definitely hook up if I get out there again. I really I do like it. I think it's just a neat place. We would go when the family went out there. We would go in the wintertime when it was, not cold, but it was cool. And going to Sedona, it was really. We took a pink Jeep tour in Sedona, went up into the mountains, and I got some great photos up there. I'm kind of an amateur photographer, and it was really really cool. It's just I'm in Atlanta, and of course the scenery in out west is very very different. So we went several times. We just thought it was just a really neat place to go. And I know people out there. I've got some cousins. I've got some cousins in Phoenix. I got some cousins in Tucson. So I really enjoy it. So I'll probably get out there again. So I will let you know when it does, if and when it does happen. Another doctor's fan is waiting for me to market. So yeah, I think that's I think that's a very wise move on your part. Just establish a relationship with somebody. Maureen says, hello, Jonathan. Hello, Maureen. I hope you're doing well. Nice to see you again. Trevor Smith. I'm 66 on disability. Okay, so Trevor's identifying a problem where the Medicare people are not able to help because of the shutdown. So there are some, so what you're dealing with is some issues with Medicare and some technical issues, which tend to drive people really, really crazy. You might reach out to is Cal Hero. Cal is an insurance business, but he does a lot of work with Medicare supplements, things like that. And he's been very generous with his time with my clients. His website is called MedicareMall.com. And if you just go info@MedicareMall.com, he'll get back to you. But he might have some suggestions about this because he's been doing this for a long time and deals with all the bureaucracy. And like I said, he's somebody I got to know through one of the, I'm not sure if he saw me on my videos or I know I've interviewed him on the podcast at one point, but he's been at a couple of the conventions I've gone to, the NADER and the NOSCR convention. But he's been very generous with his time, and he speaks to my clients quite frequently about Medicare issues because I don't know much about them. And I would, if I have Medicare questions, he's the one I call. And he, like I said, he always tends to have an answer. So, okay. FOUD, federal court remand approved. We'll get my back pay. My case since February 21. Yeah, I mean, if it goes back to that far, yeah, you should get a nice chunk of money, FOUD. I hope you do. Okay, Tip. Well, I wish you the best. Michelle, thank you very much. I really appreciate it. I think, as I've told y'all, the funds that the people, when they leave little tips, which I appreciate, goes to the Jake Ginsberg Lunch Fund. Jake is my son who does my videos, and we go to lunch at a deli, East 48th Street, if you're interested, a little Italian deli, not too far from here. And so I always have to buy him his lunch. I don't know, it's one thing when you have adult children, and Jake's like in his 30s at this point, early 30s. They never get off your cell phone plan, and they always expect you to pay for lunch. And he's actually pretty good. I got to say, I give him a hard time sometimes. He's actually pretty. He'll sometimes take me out to lunch. So he's pretty good about that. But cell phone, I can't get either one of them. I got a married daughter with a kid, and she's still on my cell phone plan. Can't get off of it. And Jake can't get off the cell phone plan. And he uses all my damn internet access. I mean, I get my bill, and they've throttled my service because you use so much of it. And so I what's the deal? And he's like, well, my home, my modem's too far from where I work. He works out of the house. He works for a big software company. And so I had to use the not the Wi-Fi. He had to use the internet from the online internet, basically, that you would use with your cell phone. So like all of our internet access has been throttled because you use it all up, and so it regenerates every month. But anyway, neither here nor there. Great kid, great young man, but he'll benefit from the $4.99. I'll just put it that way because I always have to buy him lunch. All right. I don't think so, Gojo. I don't think that the government shutdown affects anything in the appeals process. Okay, that was the link there. Thank you very much. No problem at all. No problem at all. Michelle. Okay. Michelle, thank you for, again, the tip. I appreciate that. 58 with cervical myelopathy, cervicogenic headaches, and cervical radiculopathy. Need ACDF surgery. My allergy is coming soon. Does having surgery help or hurt your case? I think the fact that you're a surgical candidate helps your case. They're not going to do neck surgery unless there's a real problem. So I think having that surgical order sends a message to the judge. So if it's coming up soon, he's probably not going to have the surgery before the hearing. I think if you just have all these treatment records, you've got MRIs, you've failed conservative treatment, now you're a candidate for an ACDF, which is a fusion surgery. That's going to help your case. I think that's going to make your case. In fact, I've got a case I was working on, supposed to do my pre-hearing with my client today. We got our times mixed up, but I was working on the brief, and same sort of thing. She's had 2 cervical surgeries. The MRIs keep showing, stenosis. They show, a recurrent bulge, I think recurrent herniation. She's got terrible headaches. She has numbness in her hands. She's got significant pain, and it's a good case. I think it's a really good case. And this almost sounds like the exact same thing. So in her case, she's had 2 surgeries. They haven't helped. But if in your case, you haven't had the surgery yet, the fact you've got an order for surgery or a suggestion in the record, that will help your case. I think you should be good. Sounds like you got a good case to me. Vegas are setting up for I didn't know that. Interesting. You're in Vegas. Alicia's in Vegas. She says they're setting it up for Formula One racing, which is interesting because I don't know if you've ever seen a Formula One race, but the streets have to be really smooth because these cars have about that much clearance from the tires to the road. So they've got to have very the track or in Formula One. Or maybe I'm thinking Le Mans. I'm not sure, but anyway, you have to have a special track for Formula One. I'm not sure. I don't know. Maybe y'all can tell me. Does Formula One just go in an oval, or it's just the one that goes through the streets? I don't remember one of the two, but I know the ones that go through the streets, they have to always repave the streets. I thought it was I thought that's what they have in Vegas, but it'll be interesting. You're welcome, Alicia. I'm glad to do them. How long does it take? Again, when you request a hearing after recon, 5-6 months typically. Okay. Thank you very much, Cowboy. It's John. I don't go by Mr. Ginsberg. Jonathan is just, that's what I go by. So, you know what? Send me an email because I want to make sure that we're in touch because you're saying Cowboy up. I don't know. I don't want to ask you your name on the live stream, but just send me an email so I know who you are so we can communicate more directly there. Okay, let's see what else we got going on here. Christie, back pay to 1 year. It's 1 year prior to the date of application. That's always been the case. That's not new. So if you apply in 2023 and you're alleging a disability onset of 2022 and you go to a hearing in 2025, you can get back pay going back to 2022. It's not 1 year from the date of decision. It's 1 year prior to the date of application in an SSDI Title II disability case. That is not new. That's not new. Sherry, the average wait time after you request a hearing, 5 to 7 months has been my experience. Okay, all right. PMFG, SSDI recipient family to send a certified letter to the post office, be compliant with the time letter. Thanks for the helpful advice. We'll fax again. Yes, absolutely. I think the more you communicate with them, the better. The more you communicate with, and I will tell you, there have been times when I've had to argue that I sent something in. This is going back in the dark ages. We had to mail stuff in. Now it's all done. It's uploaded. But I remember very distinctly a case where my client had gotten a denial notice, I think for initial recon, and the letter was dated, let's just say March 15th. It wasn't mailed until May. So when they actually got the letter, it was after the 60-day deadline. So I asked for good cause. They hired me and I asked for good cause, and they denied it. They're like, no, it's not good cause. I said, what are you talking about? Here's the postmark on the letter. Here's the date of the letter. You can see, anybody with brains can see that the letter was not mailed until like literally the day before the 60-day deadline. Didn't receive until after the 60-day deadline. Nope, we don't care. We had to start over again. And I eventually won that case. But I mean, it took an extra year and a half because we had to start all over. Thankfully, I think those days are over, because now when we submit files, we do it electronically. We get a receipt right then, and we know it's been uploaded directly. But if you do mail anything in, or you mail anything to Social Security, what I have always, my philosophy is, do it certified mail, return receipt requested, send it multiple times. If you fax it in 15 times. You almost have to go to overkill mode to deal with this. So it's just unfortunately the way it is, but that is it. All right, so Cowboy, okay, I got that. I'll keep. I made note of that. Christy says, "Good to know. Thank you very much." Okay, let's see if there's anything else here we can do. Okay, so I do want to put this here. If you find this useful, please do give me a review. Reviews are very, very helpful to me. Lets people know about it. Obviously, the more reviews I have, the better my websites do. So I really would appreciate it if you do find this live stream helpful. And also, I would tell you, if you have ideas for other videos, things you want to know, let me know. I'm always looking for ideas for videos. Sometimes I get some really good ideas from comments on the YouTube channel. So by all means, let me know that as well. And I think that Social Security right now is in a real interesting place. We'll see what happens. Are they going to change the rules? I don't know. Is the shutdown going to start having an effect on things? I don't know. We'll just have to see. But I'm hoping that we keep pushing away. And again, if you find this useful, please let your friends know. Thank you, Christy. I appreciate that very much. And all right, so it looks like we're done with our comments. We're about at the 2-hour mark, just about hour 57. So we'll go ahead and end it right now. I'll be back next Wednesday at about 8:45. And again, if you have any thoughts, any ideas about things you want me to talk about, thanks, Main Event. Appreciate that. Please do let me know. I'm more than happy to cover anything you want me to cover, and we'll get some good guests coming in. And everybody have a really, really great week. Enjoy the fall weather, and we'll talk to you next week. Thanks a lot.